Edward Burke,
Yes,
we need to discuss the old post house redevelopment.
I know the project.
This is Edward Burke, a 54-year Chicago alderman who chaired the Finance Committee longer than most politicians hold a single office. What you're about to see is what that power actually bought him, and why a federal jury just called it extortion.
Investigators have questions about your involvement.
I handled many projects over the years.
Did you request legal business from the developers?
I disagree with that characterization.
The man on the floor of that City Hall office had been an alderman for 54 years. By sunrise the next morning, federal agents would be carrying boxes of files out of the same office, past the same secretary, under the same nameplate. The Chicago City Council had seen 37 of its members convicted of federal crimes since 1972. Edward M. Burke would become the 38th. The recordings that finished him had been made by another alderman wearing a wire for the FBI. And on one of those recordings, captured in the middle of a $600 million redevelopment, Burke could be heard asking, in his own voice, whether the development team had landed the tuna. Pay attention to the number you are about to hear. 54 years in the same elected office, every one of those years working as a partner at a property tax law firm whose clients did business with the city he ran. Drop a comment if you can name another job in America where that arrangement was even legal. And subscribe if you are new here. We cover the cases the political class would rather you forget. Edward Michael Burke was born on December 29, 1943, on the southwest side of Chicago. His father, Joseph P. Burke, was a Chicago police sergeant who would later become the alderman of the city's 14th Ward. The 14th Ward in those years was a stretch of bungalows, two flats, and parish boundaries running through neighborhoods like Brighton Park, Archer Heights, and parts of Gage Park. It was a place where you knew your priest, your precinct captain, and your alderman by their first names. It was a place where those three figures often had more to do with whether your garbage got picked up than the mayor downtown ever would. Burke attended Quigley Preparatory Seminary South, the high school where the Archdiocese of Chicago sent boys who were considering the priesthood. He did not become a priest. He enrolled at DePaul University, earned a bachelor's degree, and then a law degree from DePaul's College of Law in 1968. He was 24 years old, newly admitted to the Illinois bar, and his father had just been re-elected to a fifth term as alderman of the 14th Ward. Then his father died. Joseph Burke passed away in May of 1968. By Chicago tradition, and by the unwritten rules of the city's machine politics, the seat did not pass to a stranger. The Democratic Ward committeemen of the 14th Ward met, conferred, and selected Joseph's son, Edward, to fill the vacancy. He was sworn in as alderman in 1969. He was 25 years old. He had been a lawyer for less than a year. He would hold that seat for the next 54 years. He would outlast 8 Chicago mayors. He would serve under Richard J. Daley, the elder Daley, the boss of the original Chicago machine. He would serve under Michael Bilandic, Jane Byrne, Harold Washington, Eugene Sawyer, Richard M. Daley, Rahm Emanuel, and Lori Lightfoot. He would be re-elected 14 times. He would, in long stretches of those decades, be the longest-serving member of any city council in any major American city. The 14th Ward changed underneath him. The Lithuanian and Polish parishes that had elected his father gave way to Mexican-American families. The bungalows turned over. The aldermen of neighboring wards came and went, some to retirement, some to indictment. Burke stayed. He sponsored ordinances renaming streets after fallen police officers. He delivered eulogies at firefighter funerals. He attended every wake, every confirmation, every grand opening that mattered in his ward. His political organization, the 14th Ward Regular Democratic Organization, was widely regarded as one of the most disciplined precinct operations in the city. In 1968, the same year his father died, Edward Burke had joined a small Chicago property tax law firm. After his election, he became a partner. The firm would eventually be known as Clafter and Burke. Its specialty was narrow and lucrative. It represented corporate property owners, office towers, hotels, manufacturers, retail chains. The firm filed appeals before the Cook County assessor and the Cook County Board of Review, seeking reductions in assessed property tax valuations. A successful appeal could save a single client tens of thousands, sometimes hundreds of thousands of dollars a year. The work was repeat work. The clients renewed. The fees compounded. Burke kept his law practice. He kept his alderman seat. He served simultaneously as a legislator with authority over the city of Chicago and as a private attorney whose income depended on corporations doing business in that same city. He told reporters, over the years, that there was no conflict. He told them the law firm and the ward office were entirely separate. He told them his clients did not seek anything from the city, and that the city did not steer anything to his clients. For more than 4 decades, those answers were considered sufficient. They were the kind of answer Chicago accepted because the alternative would have required Chicago to look in a mirror. The Chicago City Council, on paper, is a body of 50 aldermen elected from 50 wards, each representing roughly 55,000 residents. The council passes ordinances. It approves the city budget. It confirms mayoral appointments. In practice, it has long operated under an unwritten doctrine known in Chicago as aldermanic prerogative. Under aldermanic prerogative, the council generally defers to the wishes of the local alderman on matters confined to that alderman's ward. Zoning changes, sign permits, driveway curb cuts, business licenses, tax incentive applications, city approvals of every kind. If the alderman supported the project, it generally moved. If the alderman opposed it, it generally died. The mechanism gave each of the 50 aldermen, within the boundaries of their own ward, a quiet veto over almost every development that touched their territory. For most aldermen, that authority was a parochial tool. For the chairman of the council's finance committee, the authority extended citywide. Edward Burke chaired the finance committee for 32 years. The finance committee oversaw the city's bond issues, its workers' compensation program, its tax increment financing districts, and its review of major economic development incentives. Tax increment financing, known in Chicago as TIF, was a mechanism used to subsidize redevelopment in designated districts. The old post office redevelopment depended on it. Many of the largest real estate projects in Chicago depended on it. A project that needed TIF approval needed the Finance Committee's blessing. Practically speaking, it needed the chairman's blessing. Burke was that chairman. He was also a partner at Clafter and Burke. The firm's billing records, later subpoenaed by federal investigators, would show that across decades, the law firm represented hundreds of corporate clients in property tax matters. Many of those clients held property inside the city of Chicago. Some of them, at various points, also needed approvals from the city council or the finance committee. Zoning changes, sign permits, TIF allocations, license renewals, inspectional pass-throughs. The two streams of business ran parallel. A developer who wanted a permit needed Burke, the alderman. A property owner who wanted a tax reduction needed Burke, the lawyer. The question that haunted the federal indictment was whether Burke, the alderman, had ever told a developer that the path to one ran through the other. For a long time, that question was the kind of question reporters asked, and Burke deflected. He had a habit of citing his own ethics filings. He had a habit of pointing out that his clients were drawn to the firm by its expertise, not by his office. He had a habit of describing the arrangement as a model that other public officials might learn from. He was, by his own description, careful. Federal prosecutors came to believe he was something else. The schemes the government would put before the jury were not a list of impulsive acts. They were a pattern. They spanned years. They involved companies and institutions whose names were familiar to anyone who had ever read a Chicago newspaper. The largest involved the old post office. The building, an 8-story Art Deco hulk that straddled the Eisenhower Expressway, had sat empty for more than 2 decades. It contained roughly 2.5 million square feet of vacant interior space, one of the largest empty structures in North America. In 2016, a New York developer purchased the property and announced an $800 million redevelopment. The project required tax increment financing from the city. It also required the resolution of a long-standing dispute with Amtrak, whose tracks ran adjacent to the building and whose cooperation was needed for loading dock access. The TIF application moved into Burke's Finance Committee. The Amtrak dispute, by ordinary channels, was not a city matter at all. But Burke had relationships. Burke could pick up a phone. Burke could let a project move, or Burke could let it sit, and the developers understood the difference. According to evidence introduced at trial, Burke conditioned his assistance on a single requirement. An affiliate of the developer needed to retain Clafter and Burke for property tax appeals on the redeveloped building. The fees, over the life of the project, would have run into the hundreds of thousands of dollars, possibly more. In a series of recorded conversations, captured by another alderman cooperating with the FBI, Burke discussed the developer's progress in retaining his firm. In one exchange, after meetings had taken place and the law firm engagement was still pending, Burke asked his colleague whether the development team had, in his own words, landed the tuna. The phrase would become the most quoted line of the trial. The defense would later argue it was a figure of speech. The prosecutors would argue it was a confession. The second scheme involved Binney's Beverage Depot, a regional liquor retail chain. The owner of the property that Binney's planned to occupy, a developer named Charles Quee, needed a zoning permit to install a pole sign at the location on Chicago's northwest side. The pole sign permit was a routine item for any alderman who chose to make it routine. Burke chose to make it conditional. According to the indictment, Burke conditioned his support for the pole sign on Quee, retaining Clafter, and Burke for property tax work on the same property. Quee retained the firm. The discussions about the permit and the law firm engagement, recorded on phone calls and in meetings, did not separate the two transactions. They moved together, in the same conversations, on the same days, with the same participants. The third scheme involved a Burger King franchise in the 14th Ward. The franchise owner wanted to renovate the restaurant. The renovation required permits from the city. The permits required the alderman's cooperation. Burke, according to trial testimony, pressed the franchise owner to send property tax work to Clafter and Burke. The dollar value of the Burger King property tax engagement was modest compared with the old post office. The prosecutors did not argue otherwise. They argued instead that the pattern proved the practice. Burke was not making a calculated exception for the largest deals. He was applying the same formula to a fast food franchise in his own ward as he was applying to an $800 million downtown redevelopment. The mechanism did not change. Only the dollar figures did. The fourth allegation did not involve a law firm engagement at all. It involved a goddaughter. The Field Museum of Natural History, one of Chicago's signature cultural institutions, had asked the city council for permission to raise its general admission fee. The increase required council approval. Burke's goddaughter had applied for an internship at the museum. The internship had not been offered to her. In recorded conversations introduced at trial, Burke discussed using his city council position to block the admission fee increase. The reason he discussed for blocking it was the unrelated internship decision. The Field Museum, the recordings indicated, would be made to understand the connection. This was the fourth pattern. Personal favor as currency, public authority as collateral. The end of Edward Burke's career did not begin with a developer's complaint or a museum director's protest. It began with another alderman. Daniel Solis represented Chicago's 25th Ward, a stretch of the city covering Pilsen and parts of Chinatown and the West Loop. He was the chairman of the City Council's Zoning Committee, a position that, like Burke's Finance Committee chairmanship, gave him citywide leverage over real estate. He had served in the council since 1996. He was, by reputation, one of Burke's closest procedural allies. They had voted together for years. They had attended the same functions. They had served on the same committees. They had shared the same lobbyists in the corridors of the 5th floor at City Hall. What Burke did not know, beginning in approximately 2016, was that the FBI had Solis on tape. The Bureau had developed evidence that Solis had himself been soliciting favors from developers seeking zoning changes. Faced with the prospect of indictment, Solis agreed to cooperate. The cooperation took an unusual form. The FBI did not simply debrief him. They asked him to keep going to work. They asked him to wear a wire. For nearly 2.5 years, Solis carried recording devices into meetings, phone calls, lunches, and political events. He recorded conversations with developers. He recorded conversations with other aldermen. He recorded conversations with Edward Burke. The recordings would eventually total more than 100 separate captured interactions. Some were short, some lasted hours. Some captured Burke discussing routine ward matters, the kind of constituent service that filled most aldermanic days. Some captured something else entirely. In one recorded call, Burke asked Solis to set up a meeting with the developers of the old post office. In a later call, after the meeting had occurred, but before the law firm engagement had been signed, Burke asked Solis directly whether the developers had committed to retaining Clafter and Burke. He used the phrase that would later headline every article written about the trial. Did we land the tuna? The recordings continued through 2018. Solis kept attending committee meetings. Burke kept gaveling them to order. Each man, on the surface, conducted himself as if nothing had changed. One of them knew exactly what had changed. In the early hours of November 29, 2018, federal agents arrived at City Hall. They arrived at the 14th Ward office on the southwest side. They arrived at Burke's home in the Beverly neighborhood. They executed simultaneous search warrants. They sealed the doors of his city council office with butcher paper to prevent observation from the corridor. They carried out computers, file boxes, calendars, and phone records. The news traveled across Chicago within hours. The longest-serving alderman in the city's history was under federal investigation. Burke did not resign. The investigation that followed the raid expanded outward from the old post office and the Solis recordings. It pulled in property tax filings going back years. It pulled in client lists from Clafter and Burke. It pulled in calendars, emails, and the ordinary paperwork of a 54-year political career. Federal prosecutors, working out of the United States Attorney's Office for the Northern District of Illinois, assembled a case that did not depend on a single transaction. It depended on a pattern. They had the Solis recordings. They had the phrase about the tuna. They had business records showing the dates of city council actions on specific projects and the dates of subsequent law firm engagements. They had the recollections of developers who had been asked, in conference rooms and on phone calls, to retain Clafter and Burke as a condition of moving forward with their projects. They had the museum officials. They had the franchise owners. They had the spreadsheets that lined the dates up. In May of 2019, 6 months after the raid, a federal grand jury returned an indictment. The original charging document named Burke on 14 counts. A superseding indictment expanded the case to 19 counts and added co-defendants. Peter Andrews, a longtime Burke aide who had been present for some of the relevant conversations. Charles Quee, the developer associated with the Binnie's pole sign matter. The charges, in their formal language, read like a corporate prosecution: racketeering conspiracy, federal program bribery, attempted extortion, use of an interstate facility to promote unlawful activity, conspiracy to commit honest services, wire fraud. In practical language, they read like a description of a 54-year tenure. The case was assigned to United States District Judge Virginia M. Kendall, a federal jurist with a reputation for tight scheduling and limited patience for unnecessary motions. Burke was represented by a team of defense attorneys with deep experience in white-collar trials. They moved to suppress the Solis recordings. They moved to sever the counts. They moved to dismiss the racketeering charge on the grounds that the alleged conduct did not amount to a pattern of racketeering activity under the federal statute. Judge Kendall denied the motions that needed to be denied. She narrowed the case on the margins. She set a trial date. The smoking gun, in the eyes of the prosecution, was not a notebook or a ledger or a hidden bank account. It was the recordings. It was Burke's own voice, captured in real time, asking another alderman whether a developer had agreed to hire his law firm in exchange for the alderman's cooperation. It was a sitting finance committee chairman, on tape, treating city approvals and law firm engagements as halves of the same negotiation. The defense knew the recordings were coming. They knew the jury would hear them. They prepared instead to argue context. The conversations, they would say, were the natural shop talk of a long career. The references to law firm work were not conditions. They were observations. The pattern the government called extortion was, in the defense view, the way Chicago politics had always operated and operated still. The jury would be asked to decide which framing was true. We are heading into the courtroom now. Before we do, if you are still here this far into the story, you understand exactly what kind of channel this is. Subscribe and stay. The verdict in this one took a federal jury 23 hours of deliberation across 4 days, and what they decided is worth the wait. The first day of trial was November 6, 2023. The case was tried in the Everett McKinley Dirksen United States Courthouse in downtown Chicago, a building Burke had walked past on his way to political fundraisers for half a century. He arrived each morning in a dark suit, accompanied by his wife, Ann Burke, a former Illinois Supreme Court justice who had retired from the bench earlier that year. He took the same seat at the defense table for 33 trial days. The government's witness list ran to 38 names. It included developers, business owners, museum officials, FBI agents, financial analysts, and aldermanic staff members. It did not include Danny Solis. The defense made repeated reference to his absence. Solis would not testify. His recordings would. The prosecution played excerpt after excerpt. Some lasted 30 seconds. Some lasted 10 minutes. The jurors listened with transcripts in their laps. They heard Burke's voice. They heard his cadence. They heard him discuss the old post office, the law firm engagement, the museum, the goddaughter, the pole sign, the franchise. They heard him ask about the tuna. When the prosecution rested, the question of whether Burke himself would take the stand became the most watched decision in the courthouse. He did not take the stand. His attorneys argued the case on cross-examination and in closing. In closing argument, the lead defense attorney spoke for more than 2 hours. He argued that the government had collapsed coincidence into conspiracy. He argued that the firm's clients were drawn to its expertise, not coerced by its founder's office. He argued that the recordings, removed from the rhythm of daily aldermanic work, sounded sinister only because the jury had been trained to hear them that way. He invoked Burke's age. He invoked the half-century of constituent service. He told the jurors that the case against a 79-year-old public servant rested on a fishing metaphor. The government, in rebuttal, returned to a single recording. He asked, the prosecutor said, whether they had landed the tuna. That is not the language of legal expertise. That is the language of a transaction. The defendant was the chairman of the finance committee. The developers needed the finance committee. The defendant was a partner at a law firm. The developers were told to hire that law firm. The recording does not require interpretation. It requires a verdict. The jury began deliberations on a Monday morning in December. They returned a verdict on the afternoon of December 21, 2023, after approximately 23 hours of deliberation spread across 4 days. They found Burke guilty on 13 of the 14 counts that had been submitted to them. They acquitted on a single count. They could not reach a verdict on a small number of additional counts that the court had separately handled. Burke sat at the defense table as the verdict was read. He did not speak. His wife sat behind him. The courtroom was full. Outside the courthouse, the defense attorney told reporters his client was disappointed and would consider all available options on appeal. Inside the courthouse, the prosecutors gathered their materials and left through a side door. Sentencing was set for the following year. The probation office's presentence report, prepared in advance of the hearing, calculated an advisory guideline range that the parties would dispute at length. The government sought a sentence of approximately 10 years. The defense sought probation. Judge Kendall would resolve the difference. On the morning of June 24, 2024, Burke returned to the Dirksen courthouse for sentencing. He was 79 years old. He had spent more than 3/4 of his life as a public official. He had been retired from the city council for slightly more than a year. The hearing was attended by reporters, family members, and former colleagues. Letters of support had been submitted on Burke's behalf by hundreds of people, including former judges, civic leaders, and constituents from the 14th Ward, who described decades of quiet assistance with funerals, immigration paperwork, parish fundraisers, and elderly relatives who had needed someone to call the city for them. Letters from victims and from members of the public had also been submitted. The judge had read them all. Burke addressed the court briefly. His statement was short. He spoke of his family. He did not contest the verdict. Judge Kendall delivered her sentencing remarks from the bench. She described the conduct as a serious abuse of public trust. She noted that Burke had held public office longer than almost any official in modern American urban politics. She acknowledged the letters of support, the lifetime of constituent service, and the absence of personal enrichment beyond the law firm fees that the indictment had described. She also noted the recordings. She noted that the jury had heard them. She noted that they spoke for themselves. And she noted that a man who had spent 54 years writing the laws of his city could not credibly claim he had failed to understand them. She sentenced Edward M. Burke to 2 years in federal prison. She imposed a fine. She ordered him to surrender on a date later set in the fall. The sentence was substantially below the government's request. It was substantially above the probation the defense had sought. It was the resolution of a case that had taken 6 years from raid to sentencing and 54 years from swearing in to conviction. Burke reported to a low-security federal facility in the months that followed. He was not assigned to a maximum security unit. He was not placed in protective custody. He served his time among the population of an ordinary federal camp, in the way of any 79-year-old white-collar offender. His wife visited. His former colleagues did not. In early 2026, his attorneys filed a petition with the Office of the Pardon Attorney seeking commutation of the remainder of his sentence. The petition was pending as of this recording. When Edward Burke was convicted on December 21, 2023, he became the 38th member of the Chicago City Council to be found guilty of crimes related to his office since 1972. 38 aldermen, 50 years, 1 city. The number is itself an indictment, of a kind that no single prosecution can deliver. He had served in the chamber longer than anyone. He had chaired its most powerful committee longer than anyone. He had practiced law on the side of his service for every year of those decades. And for every year of those decades, the question of whether the two roles could honestly coexist had been answered with silence. The recordings answered it differently. This case was half a century in the making, but the case waiting on the right-hand side of your screen unraveled in a single afternoon. Click it now.